turn to at least one more situation in my remaining minute or so, given the fact that this is curtailed. And this is not in our papers, but obviously it's a complete and probably the most obvious distortion of the facts. The Commonwealth suppressed one of the most obvious pieces of exculpatory evidence in the entire case, and that was a piece of evidence that they know torpedoes their entire case and their theory of this case, and that's Jennifer McCabe's Google search at 2:27 a.m., how long to die in cold. They had her phone at the time of the grand jury. They had her complete extraction of that phone at the time of the grand jury. They had a Cellebrite report, Your Honor, at the time of the grand jury, and yet they did not present this evidence. They claim, oh, well, we didn't have the right version of the Cellebrite software. That's on them. That's not our fault. Certainly not Mr. Reed's fault. That's their fault. Get the right software. If you're going to bring this case, do it the right way.
Right.
They say their argument is, well, we just didn't have the right software, so we didn't have the information. That's not true. Yeah. They did have the information. It was sitting in her phone. They just didn't do their job in extracting.
Jackson.
And should the Commonwealth once again stand up in some sort of desperate pitch to dispute that time and this critical evidence, the court should note the following. Not only does the Cellebrite report confirm the search and the time of that search, not only do our experts confirm the search and the time of that search, but now a Quantico-trained special agent with the FBI's Regional Computer Forensic Lab. In other words, the United States Federal Bureau of Investigation also specifically confirms that that search was made on Jennifer McCabe's phone, and it was made on or before 2:27 and 40 seconds a.m. on January 29th, 2022. That fact, Your Honor, is no longer open for debate.
That's why she's not there.
Woo!
That's why
The
she's not
feds confirmed
None
it.
of that was presented before the grand jury.
The feds confirmed it.
I'll conclude by
Yes!
saying any one of these examples, and I didn't touch on all of them, but any one of these examples, the gift giving, the babysitting, the telephone extraction, the Google search at 2:27 in the morning, all of these, any one of these would be enough to dismiss the charges as they sit here today. But the cumulative effect of this deception and all of it, this distortion in front of the grand jury, is too much for the court to ignore. The simple fact, Your Honor, is the presentation before by the Commonwealth before the grand jury and the state court action, it just wasn't fair. That's the easiest way to say it. It just didn't give Ms. Reed a fair shot. It just didn't. That presentation was packed with lies, known lies by the investigators, and the omissions and the manipulations and deceit by the very people that are supposed to be the ones that we in the community can trust, the ones that are supposed to protect our interests. And the law does not allow this sort of conduct to go unchecked. When the remedy, when this sort of travesty of justice occurs, is established by this state's Supreme Judicial Court, and that is dismissal of the indictment in its entirety. And it is not enough, and I'll be surprised if I don't hear it today, but something suggests, based on the moving papers that we just got from Ms. McLaughlin and Mr. Lally, are, well, Your Honor, we didn't know. We didn't know about the text messages. We didn't know about Proctor. We didn't know about Lank. All that stuff was revealed through the federal grand jury. It doesn't matter that Ms. McLaughlin individually didn't know, or Mr. Lally can say, I claim ignorance, I didn't know either. It's enough that an arm of their institution, law enforcement, they knew, and that was their job to tell the truth. That was their job not to fool or distort the Commonwealth. I'm sorry, the grand jurors. With that, Your Honor, it's always interesting to hear an argument that suggests there's nothing to see here. And that's exactly what Mr. Lally did yet again. He said, look the other way, look the other way. Oh, it's the defense that wants you to look the other way. We don't want you to look the other way, Your Honor. We want you to look directly at the evidence of the compromised relationship
the truth
that Proctor had and hid. That's what we want the court to look at. He suggests, oh, well, there's just a couple of text messages. It's no big deal. It's the fact is, Your Honor, she really hit him. She really hit him with the car. Let's remember, she really hit him. And these text messages, they mean nothing. Mm-hmm. We're talking about the integrity of a sitting grand jury and the presentation before that grand jury. What Mr. Lally now has in his possession, but he didn't mention Now that he says, oh, well, she killed him. Let's just get on with it. She killed him. He's already tried and convicted her in his mind and tried to do it in this courtroom. Doesn't quite work that way. Now Mr. Lally has in his possession another thing from the feds that we didn't have access to. The federal investigators hired, independent of us, we had no idea, and independent of the Commonwealth, hired a professional reconstructionist, 3 PhDs, to look into exactly this issue. Did Karen Reed's car, did her SUV
Here we go.
make contact with John O'Keefe? And their conclusion to a person was his injuries were inconsistent with the damage on the car.
Wow.
There it is.
The damage on the car was inconsistent with having made contact with John O'Keefe's body.
There
In
you
other
go.
words, the car didn't hit him, and he wasn't hit by the car.
The FBI.
Period. Full stop. That's their independent expert. Not
Wow.
ours. Not somebody on our payroll.
Wow.
Like Mr. Whiffen, or one of their experts, or Trooper Guarino, who's an arm of the agency. This is an independent federal government witness. or
Wow.
series of witnesses
Woo.
who said
Wow.
unequivocally, that car did not hit John O'Keefe. and
Wow.
John O'Keefe was not hit by that car. But he didn't mention
This
that.
is amazing.
Second, here,
Wow.
the